there's some real questions about protectability. So there's aspects of the guitar that they patented at the very beginning, but the patents are long since expired. So they patented the bass guitar, that's gone. They patented the tremolo system. Again, that's long since expired because the patents were issued in like 1954.
Yeah.
They tried to get a trademark on the body design, and that was in 2009, but that was an unsuccessful effort, and I think you could probably comment to why.
Where you're talking about a product design like this, we call it trade dress. So it still functions as a trademark, but it's the overall look and feel of something. The reason why it would be helpful and important if Fender had been able to prevail in gaining trade dress protection for these elements is because, unlike copyright and patent, trademarks are potentially perpetual. So trademark rights in the United States are based on use. So long as you continue to use that trademark or trade dress in commerce, those rights still attach. Patent and copyright, because they're in our Constitution, have a limited period of time of exclusive use. For trade dress protection in particular, in order to be protectable as under the trademark laws, you have to show what's called acquired distinctiveness. And acquired distinctiveness is essentially just, do consumers associate, when they see this trade dress design, this product design, do they associate that exclusively with Fender as the source? And Fender put in lots and lots of evidence. They sued many guitar makers, and so all the guitar makers put in a lot of evidence. And even looking at the years of use, years of advertising, expenditure on advertising, that wasn't enough. And the main driver of that was essentially that what the other manufacturers were able to put in is like, look, but on the other hand, you have to see how many third parties there are that have been using very similar, if not identical designs for years. And that's what ultimately sort of lost the day for Fender in the Trademark Trial and Appeal Board. There was also one federal court decision where Fender won in the lower court, but that decision was reversed on appeal. So they haven't done so well in trying to establish their trademark trade dress rights. And I gather that's, now they're trying to make more hay out of this, I think it's German decision out of Germany, to see if they can get better traction there.
Well, if anything, it's really a statement of you shouldn't sleep on your rights, because they probably could have trademarked it at the beginning.
If it was 1960.
And then they didn't. And then everybody copied it for decades. And then they're coming back after the fact, but it's sort of too late at that point because it's no longer distinctive. Everybody else has used it.
Yeah. This, we call it widespread third-party use. That's a very powerful argument because that shows that, that distinctiveness, if you ever had it, has slowly been eroded over time by all of these third-party users that you haven't enforced against. Under trademark law, you actually have a duty to enforce your mark. And if you don't enforce that mark, you very well may lose whatever trademark protection you may have had.
We talked about this before we started. The one thing that actually probably is still protected is the logo that's on the headstock and the name of the Stratocaster. And then obviously the Telecaster for their other, but that's a pretty minimal level of protection relative to the rest of the overall product here.
You can see why some of these comments among, guitar aficionados out there on Reddit and YouTube, you can see why they might have this initial gut reaction that like, well, if you're really trying to protect this shape and it has been in use for so many years, aren't you really trying to stifle competition?